Good evening, and welcome to all of you to this event on Talking Disputes. The evening we'll be discussing the arbitral award in the investor-state dispute, Philip Morris versus Uruguay. First of all, my name is Pedro Rofe, Senior Associate from ICSID, and responsible for work in ICSID on innovation and intellectual property. I had a previous career, especially in the United Nations Conference on Trade and Development, working on similar issues. My responsibility today is to moderate this important event. Joshua has prepared for me a very precise script that I will attempt to follow as appropriate. Well, thanks to you for detailed preparations for this occasion, made for this event, and the fact that you have gathered such a prominent panel that we will have, and we will listen carefully to what they have to say to us. Talking Disputes is a series of events organized by ICTSD, the International Center for Trade and Sustainable Development, and WTI advisors. It is designed to allow for the discussion of specific international trade disputes by expert and interested public. Today, events focus on an investor-state dispute instead of a traditional WTO dispute. Let me tell you that this event is being streamed live online, and we are also receiving comments and questions from our Twitter followers. We will try to address as many questions and comments that will be submitted online before the end of the event as time permits. The subject of our discussion today, as I mentioned before, is the dispute decided by ICSID Tribunal of Arbitrators on July of this year. In short, the Philip Morris case and the Oriental Republic of Uruguay. Before giving the floor to the main actors on this occasion, let me make some personal introductory remarks that are not part of the script that I received. The case that we will be discussing has attracted great attention by specialists, media, and the general public. The case deals with the intersection of different legal regimes: trade, investment, intellectual property, health, and not least human rights. At the heart of the case is the interface and coherence between distinctive international legal instrument and domestic law. At play are at the same time important fundamental principles around property right, state regulatory power, and the authority of investor-state disputes. The relevance and possible implication of the case might suggest course of action in other related pending cases. At ICSID, the case around NAFTA agreement brought by Eli Lilly against Canada on the revocation of pharmaceutical patents and the notion of taking of property. At WTO, the state-to-state dispute against Australia. At the same time, in my view, and in the back of many minds, the case relates to present-day deliberations around globalization and the discontent with trade agreements, their opacity, and more precisely on the mechanism for investor-state disputes. The cases of CETA, TPP are only examples. I acknowledge at the same time that there is a lot of misinformation and lack of evidence-based debates on this question that I have mentioned. The dialogue today is a modest contribution to more informed discussions on these issues. As I said before, we have 4 very distinguished speakers that will take the floor and will present the case and observations from their respective perspectives. Let me briefly introduce them in the order that they will be speaking. I understand that bios are available, then I will not go into details. First, Krista Nadakabukaren Scheffer. I did well?
Very well.
Currently acting director of the Center for Human Rights Studies at the University of Zurich. Krista, that will have around 15 minutes, will provide an overview of the key findings of the arbitral tribunal decision. Krista will be followed by Sabina Sacco, partner at Levy Kaufman Kohler. Sabina specializes in international commercial and investment arbitration. She will comment on the implication of the dispute from the perspective of investment arbitration. Ernest Ulrich Petersmann, Emeritus Professor for International and European Law and former head of the Law Department of the European University Institute in Florence. Uli will comment primarily on WTO law and relations to this case. Finally, Ben McGrady is legal technical officer in the Prevention of Non-Communicable Diseases Department at the World Health Organization, WHO. And Ben, naturally, will focus on public health aspects of the case. Then we will proceed with the main presentation by Krista. You have the floor.
Thank you very much. It's my pleasure to be here, and I want to thank you, Pedro. I want to thank you also, Yachwan, for inviting me. I think this is a wonderful opportunity. I've never done talking disputes, even though I talk a lot about disputes throughout my career. I'm sure many of you know a lot about this case already and a lot about the trade and investment systems, but so I'm just going to be giving you, in my 15 minutes, a brief overview of the background of it and of the findings. And I'm happy to sort of discuss further my thoughts about the implications of it afterwards. I think 15 minutes, I'd probably be the first one to ever say something like, well, I probably won't fill it up, but I will certainly fill it up, but I'll try to stick to my time so that we have plenty of time for questions. And I know that my colleagues on the panel are going to have further development of many of the things that I'm going to say, so I don't want to take too much time going over things that you're going to hear anyway. But just so that you have a good overview of what we're talking about. The case is, of course, between two parties. And in the investment system, we do have this investor-state dispute settlement mechanism, which puts a private actor against a state directly at the international level, which is its sort of claim to fame. And so here we have Philip Morris companies. There were several of them involved. There was Philip Morris Brands, Philip Morris International, Philip Morris Switzerland, which lent the nationality, and their 100% owned subsidiary Abal, which was the Uruguayan company. So this case was against Uruguay, the state, and it was brought under the Uruguay-Switzerland BIT. Now, Abal had been acting in the tobacco sector in Uruguay for a long time. It had been there since the 19th century, in fact. And until 2003, they were having a pretty good time of it. Uruguay was relatively tobacco friendly, and even up until 2002, they were offering them some tax advantages to expand production and that sort of thing. But as of 2003, clouds started to arise on the horizon for them, because in 2003, Uruguay signs the Framework Convention on Tobacco Control, ratifies it in 2004, and by 2005, it goes into effect. So the tobacco control policy becomes much more stringent. And insult really became injury in 2009 when the Uruguayan government passes two ordinances that became then the target of the claims. And the first one is the single presentation requirement. And that is simply a limitation that was put on the use of variants. So tobacco products have brands, and then there are variants on the same brand, and the ordinance said you cannot do this anymore. You can only have one variant per brand. Now, the idea behind this, according to Uruguay, is that use of variants is misleading. It misleads the consumers into thinking through the different colored packaging, through the different sort of wording that they put on it, that some of these variants might be safer than others. Okay? So they said only one. And Abal had 6 brands, but 13 variants. So, I'll do the quick math for you. 7 of those had to go, which they said was about 20% of their domestic sales. Okay, so no more variants. The other regulation that was being argued about was the 80-80, I call it the 80-80 regulation. This was the regulation that said 80% of the package front and 80% of the package back have to be covered with pictorial and textual warnings. Okay, warnings about the health effects of tobacco. Now, the idea behind this one is bigger is better. They already had 50% coverage, and they increased it then in 2009 to 80% coverage. There was no, and this is, I think, also important, there was no argument about whether or not tobacco is harmful to health. Okay, so that was agreed upon by both the claimant and the respondent. So the complaint was 80% of the package getting covered up with pictures, which are particularly revolting, right, takes away their ability to enjoy the use of their trademark, because the trademark can't be big, it now has to be small. So this was their major complaint. And the actual claims themselves then were the following: expropriation, fair and equitable treatment, use and enjoyment of their investment, the violation of the observing commitments on the part of Uruguay, and then a denial of justice claim. And I'll talk mainly about the first 4. And the request then was that either Uruguay withdraw both of these measures and give them some compensation for what they've lost up until now, or they compensate them for $22.26 million and interest and that sort of thing as well. Okay. Now, Uruguay responds to the claim with several jurisdictional arguments. And they said, well, the tribunal cannot hear this case because certain prerequisites were not fulfilled. One of them being that Philip Morris might not have consulted for 6 months, which is part of the consent of the arbitration. That was actually later kind of taken away. And then there was the 18-month litigation prerequisite that was in the treaty saying once you have litigated domestically for 18 months and gotten no satisfaction, then you can bring a case. They had not litigated actually for the full 18 months when they brought the case, although by the time of the jurisdictional decision they had. And finally, the question of whether Abal even had an investment, because Uruguay argued in order to be an investment, the project or the investment activity must have contributed to the economic development of Uruguay. And Uruguay argued there was no net investment, no net contribution to economic development, because all of the benefits of the taxes and sales and employment that Philip Morris had been making were more than offset by the additional healthcare costs to the system because of Uruguayan people smoking and getting sick and having to be taken care of. Now, we can go into this later in the discussion. I don't want to focus too much on the jurisdictional award because we're looking at the other award. But I think it's important to set out that the tribunal denies all of these jurisdictional objections. Okay, so we move on then to the regular, claims, the merits. Now, the first claim was based on Article 5 of the BIT, which is expropriation, and specifically indirect expropriation. That is, they are not claiming that the government took over their property for itself, but rather that they regulated it in such a way that it had the same effect on them. And what the tribunal had to do, first of all, was determine what is the nature of indirect expropriation. Now, this is something that has been litigated back and forth in investment for a long time, and so my colleague will probably tell you all about that, but let me just tell you what the tribunal said. They said, in order to have an indirect expropriation out of a regulation, right, there must be a major adverse impact on the investment. That is, intensity must be great and the duration must be significant. Now then they looked at the 80/80 regulation and they said, look, what you're claiming is that we have expropriated your sort of price, sort of the benefits of having a brand. And they said, that's no good. And for the single packaging requirement, though, we need to go, single presentation, we have to go a little further. We look a little bit further. So first the tribunal said, well, is a trademark even property that can be expropriated? Do you have the right to use a trademark such that if we limit your right, it could actually be considered an expropriation at all? And I don't actually know why they went into this question so deeply, because they could have answered it with their second finding. But what they said was, yes, there is property rights in a trademark, but it is not an absolute right. That is, it is a relative right that you have the right to prevent others from using your trademark, as in other private parties, but vis-a-vis the state, you only have a relative right. The state can actually infringe that right for public purposes. Okay, so, but they could have, did they, is the question. And here we have then the question of what is the standard for indirect expropriation? And the tribunal then says customary international law itself essentially excludes from compensation requirements any measure that is a valid exercise of police powers. A valid exercise of police powers. So here, the tribunal's view, the adoption of the measures was a valid exercise with the consequences of defeating the claim for expropriation. Okay? So what is exactly a valid exercise of police powers? It is regulatory action taken in good faith with the goal of public welfare, non-discriminatory and proportionate. And it goes through the history of the single presentation requirement and concludes that's okay. That was a valid police powers exercise, therefore no expropriation. Now, one thing that I think here is really important is that they deny the need to demonstrate a causal effectiveness of the regulation to be considered a valid use of police powers. Okay? They don't need to show effectiveness. You just have to show a good faith effort from the beginning. Okay, so the next claim, fair and equitable treatment. And here we're going to Article 3.2. Each contracting party shall ensure fair and equitable treatment. It says nothing about international minimum standards. So for those of you who are aware of international investment law, this is something important. Philip Morris claims that the measure violated fair and equitable treatment, saying that this BIT standard is an autonomous one. That is, that the standard of treatment they are owed by the state is higher than just regular old non-willfully intent, bad faith kind of thing. And they say Uruguay, anyway, had no evidential basis of the effectiveness on which to pass these measures. And in fact, these measures were ineffective. So this was really kind of unfair. Now, the tribunal said a few interesting things about FET. And they imply sort of that there is no such thing as an autonomous fair and equitable treatment standard unless it would be explicitly excluded from being part of the customary law, because they say customary international law has to come into the interpretation of any provision. So even if you don't mention the minimum standard in your provision, you still have to essentially use the international minimum standard. And so they use this pretty low standard of treatment. And then they say, let's look at the facts of the case. Was there transparency and legitimate expectations and these sorts of things? And so what they do is they then look at the single presentation requirement as a question of fair and equitable treatment. And they say the standard we're going to use here in terms of arbitrariness, for instance, is the ELSI standard. That is, that it would shock or surprise judicial propriety if it, that the treatment is so bad. And here they say they're giving the government a lot of leeway to be reasonable and rely on other people's work. And I think it's particularly important then to look at both of these little quotations. One is for countries with limited economic resources, you can rely on the work done in the international community on this. So using WHO figures and facts is okay. Uruguay didn't have to do its own special study. The second one that I think is quite interesting, and this is something that I'd like to come back to in the discussion if I could, seed the discussion a little bit, would be the possible over or under inclusiveness was unsurprising given the relative novelty of this regulation. What the tribunal does consistently throughout this decision is give states the rights to try it out. Just try something. You see a problem, try to solve it. And if you're going to try to solve it in good faith and you mess up, well, that's okay. We're not going to let a company sue you on the basis of that. That seems to be kind of the underlying message. They then continue on looking at arbitrariness also of the 80-80. Here, I think, once again, you see this sort of deference to the government saying some limit had to be set. The balance was very largely a matter for the government. Okay, so whatever you're going to decide, we'll go with that. Regarding arbitration, they're talking about was there, was reason entirely lacking? Did you have absolutely no justification? Here they said, look, you got to strike a balance. That's good enough. Legitimate expectations also was discussed. And here I think it's important to point out that the limits on the legitimacy of expectations is that of requiring a specific commitment from the government to that particular investor. And unless you have that, you're not going to have a successful claim. And again, they underline how novel approaches are going to be okay, saying the fair and equitable treatment standard does not preclude governments from enacting novel rules, even if these are in advance of international practice. I think this is something that probably Uli Petersmann will bring up because it's something that looks quite different, I think, in the WTO. I'm going to speed up and go on to the use and enjoyment. This we can kind of forget about. Philip Morris basically said, this is the same thing as arbitrariness, and the tribunal said, yeah, well, if you say that, then you've just lost it anyway because you lost on arbitrariness. And then the observed commitments. And here we have a question of, was this clause of Article 11 an umbrella clause? The tribunal says, yes, it was. And what does that mean? An umbrella clause said any commitment the government makes to the investor must be upheld. Philip Morris claimed that they had a commitment from the government through trademark rights. By registering the trademark, the government had given them a commitment that they could use their trademark. The tribunal said, well, it is an umbrella clause, but you get no particular commitment coming out of generalized legislation. Why? Because even if the trademark belongs to you, the conditions of using it can be changed through general legislation. Therefore, it's not personal to you. There were a couple of denial of justice claims. I'm going to leave them to the side because I think we can discuss them in the discussion if we want to. They were basically specific to Uruguay's governmental and judicial setup. The reason that they're important in this is because there was a dissent, and the dissent was basically focusing on the denial of justice issue. So we can come back to it if you want, but I think in terms of bigger picture items, sort of more generalizable conclusions, we can skip it. And I guess my only concluding word would be, does this decision leave open a lot of space for the next kind of packaging regulation? Thank you very much.
Many thanks, Krista, for this excellent overview of the case. And no doubt that we will come back. And you have raised a number of questions that no doubt there will be comments to that. But why don't we proceed with Sabina, and you have 10 minutes.
Good afternoon. Good afternoon. I'd like to thank Krista for her very thorough overview of the facts and findings of this case. I'm afraid there will be a little bit of overlap between what I'm going to discuss and what she has already presented, but I am going to go deeper into the tribunal's findings on expropriation and fair and equitable treatment in order to assess their implications in the broader context of investment law. So this is just a little overview of what I'm going to talk about. One of the most difficult questions in investment law is whether international investment agreements protect investors from regulatory change. Currently, we have about over 3,000 bilateral investment treaties and several multilateral treaties, all of whom afford foreign investors with certain substantive rights that aim to protect their investments in order to attract investment. So basically what the state does is in order to attract investment, it will offer foreign investors certain enhanced levels of protection, which I'm sure most of you are familiar with. These substantive rights include the obligation not to expropriate unless it is done under certain conditions, to treat investments fairly and equitably, not to impair their investments through unreasonable and discriminatory measures, and to observe commitments that might have been undertaken by the state vis-a-vis the investors' investments. This is what is called the umbrella clause that Krista just mentioned. And these treaties also give direct recourse against the state, which is usually, what usually happens is that an investor that believes these obligations or these rights have been breached can directly sue the state at the international level, and usually does it through an arbitration such as the one that we are seeing now. So Philip Morris versus Uruguay is exactly this kind of case. Here, what happens is that the claimants have argued that the Uruguay has breached the Switzerland-Uruguay bilateral investment treaty through basically two challenged measures: the single presentation regulation that Krista just explained and the 80/80 regulation. And it brings all sorts of claims based on these two regulations. They claim that their investments have been expropriated, that these measures have treated their investments unfairly and inequitably, have impaired the use and enjoyment of their investments through unreasonable measures, have violated the umbrella clause, and they also separately argued that there has been a denial of justice. This denial of justice claim, as Krista mentioned, arises not from the measures themselves, but from the treatment that the courts of Uruguay gave them in domestic litigation. So this is a classic example of an investor challenging a general good faith regulation. And this is an issue that is a very hot topic in investment arbitration, because investment treaties were usually or originally thought to help investors avoid or to protect investors from direct and outright takings from the state or from manifest injustices. However, in the last 10, 20 years, investors have been suing states for regulatory action, arguing exactly what Philip Morris is arguing in this case. So I'm going to focus on the expropriation analysis and on the fair and equitable treatment analysis. Here you have the expropriation provision in the treaty, which I have broken up in 3 points. First, neither of the contracting parties can take either directly or indirectly measures of expropriation, nationalization, or any other measure having the same nature or the same effect against investments belonging to investors of the other contracting party, unless these measures are taken in accordance with these 4 conditions. This basically means that expropriation is permitted, but only under certain conditions. And then the provision provides that the amount of compensation shall be settled and paid without delay. This is a classic expropriation provision with a few tweaks that we can discuss later in the interest of time. But how does a tribunal look at an expropriation claim? There are 3 main inquiries. The first one is, has there been an investment? The second is, has there been an expropriation? And for this, we will go into this later, the key questions when you're looking at an indirect expropriation claim are, has there been a substantial deprivation of the investment? Is the measure permanent? And is this a legitimate exercise of the tribunal's police powers? And I will come back to this later. Once you have found that an expropriation exists, you must determine whether this expropriation has been lawful. And if the conditions set out in the treaty have been met, then that provides for a lawful expropriation. But it is important to bear in mind that even lawful expropriations require the payment of compensation. The first inquiry that Chris already went into is, was there an investment? And here it was undisputed among the parties that trademarks and goodwill are investments, but there were 2 preliminary questions that the tribunal wanted to address. The first one was, did the claimants own the banned trademarks? And this is because Uruguay had argued that the claimants did not own their trademarks because they had modified them in order to comply with previous tobacco legislation and had not re-registered them in their current form. So Uruguay said, well, you don't own them anymore, so they cannot be expropriated. The claimants had denied this, saying that their trademarks were retained their distinctive character and as such were protected. Ultimately, the tribunal found that it did not need to determine conclusively whether these trademarks were owned or not, because in light of its findings afterwards, it was not going to be necessary. However, for the remainder of the analysis, it assumes that that the claimants own their trademarks. And there's an important point here, which is that the determination of whether an asset is owned has to be done under the proper law of that asset. And in this case, this law is Uruguayan law. So the role of domestic law in determining whether an expropriation has occurred is very important. The second question that already Krista went into, so I'm not going to address it very long, is whether a trademark conferred the right to use or only the right to protect against the use by others. And here the tribunal found that there was no absolute right to use a trademark. There was only an exclusive right to exclude others, which was always subject to the state's regulatory power. But that being said, it was an asset that could be expropriated. So the tribunal goes into the second inquiry. Now that you have established that there is an expropriation, the question is, there is an investment, has there been an expropriation? So here the analysis of 2 measures. For the 80/80 regulation, the tribunal found that there was not even a prima facie case of indirect expropriation. And here, well, we can perhaps discuss later whether this analysis is satisfactory. I mean, the tribunal devoted a single paragraph to dismiss this claim. It finds that a limitation of 20% of the space available to such purpose could not have a substantial effect on the claimant's business, since it consisted only in a limitation imposed by the law on the modalities of use of the relevant trademarks. Well, I think this is a very broad statement that would require perhaps a little bit more analysis into the evidence, but we can discuss that. We'll leave that open for discussion. Then, for the single presentation requirement, the tribunal, as Krista already mentioned, its analysis was, well, mainly there has been no substantial deprivation of the investments owned by the claimants. And here, what is interesting is that this is an analysis that has to be done in light of the claimant's investment as a whole. The analysis is not, did you expropriate this or that trademark? The analysis is, having taken the measures as a whole, have they substantially deprived the claimants of their investment as a whole? And the response was no. In fact, the claimants had continued to make a profit, and their argument was that they would have made more. So the tribunal concluded there is no expropriation. But what is really interesting in this case is that in addition to this reason, and this appears to apply to both measures, is that the challenge measures were a valid exercise of the state's police powers. So this is a very controversial point, and why is it so controversial? Let's recall what the analysis is for an indirect expropriation claim. There's a three-step analysis. You have an investment, has there been an expropriation, and then is the expropriation lawful? And it is in this third step when you usually discuss whether there has been a public purpose or not. But as I already mentioned, the fact that you have a public purpose doesn't take away the fact that you must compensate. So even if you have a lawful expropriation that has been carried out in order to achieve a public purpose, it will generally give rise to the obligation to pay compensation. However, what the tribunal is saying here is a different thing. They're saying that's very well, that's in the treaty. However, under customary international law, we have a different doctrine, which is what is called the police powers doctrine, which is set out here in the third restatement of the Foreign Relations Law of the United States, according to which a state is not responsible for loss of property or for other economic disadvantage resulting from bona fide, general taxation, regulation, forfeiture for crime, or other action of the kind that is commonly accepted as within the police power of states. So on this basis, the Philip Morris Tribunal finds that there's no expropriation at all. So this is, what is interesting about this is that there's no consistency among tribunals about whether this police powers doctrine should be used or not. For instance, I've quoted here, and I will not read it in the interest of time, but you can perhaps do so. The Santa Elena versus Costa Rica case made it clear that even if a property is expropriated for a laudable measure, objective, such as an environmental purpose, the state's obligation to pay compensation will remain. And there are many tribunals that have followed this. On the other end of the spectrum, we have tribunals that have found that the principle of police powers will preclude the finding of an expropriation, such as in the case of Saluca and Methanex. Here, tribunals normally, and this is also what the Philip Morris Tribunal found, will require that this be a bona fide measure for the purpose of protecting public welfare. It must be non-discriminatory, and it must be proportionate. And what is interesting, what I think is that we must focus on, is that it is not every public purpose that will give rise to the police powers doctrine. It has to be a heightened level of public purpose, usually focused on public welfare, such as health, safety, and environment. And I want to highlight that this is the current trend these days. We have other cases such as, I had quoted it here, the Chemtura versus Canada award that said pretty much the same, in the context also of protecting public health. And then the newer generation of treaties is including a carve-out provision, such as the ones that are quoted here on the slide, and they are in the US model bid and in the CETA, in which this type of public measure will not constitute an indirect expropriation unless, in very rare circumstances, whether, as the CETA says, when the impact of a measure or series of measures is so severe in light of its purpose that it appears manifestly excessive. I don't know whether I have time to go into the fair and equitable treatment claim. 1 minute? I will go very quickly.
Because you are Chilean. Huh?
Because I'm Chilean. We talk too much. I'm going to say very briefly, I'm not going to go into what is a fair and equitable treatment claim. I'm just going to go into what was the tribunal's findings. Very quickly, what did Philip Morris say? They said the single presentation requirement and the 8080 regulation are arbitrary because they do not have a public purpose, or they are not aligned with the public purpose that they say they are supposed to be furthering. They also say that it's in breach of their legitimate expectations and that it's in breach of Uruguay's obligation of legal stability. So the tribunal, what does the tribunal say? It says that the only thing that matters is that the measures be aimed at a legitimate public purpose, that there's a legitimate connection between the public purpose sought and the utility of the measures, that it will defer to the state's judgment in this kind of a decision, and that the only question is whether there is a manifest lack of reasons. So this is the holding that I don't have the time to read out to you. And it basically says the same thing on both, and it acknowledges that there was sufficient evidence at the international level that Uruguay did not have to conduct its own studies, that it was sufficient for Uruguay to hold to what had been said by the World Health Organization and others. And what I want to highlight here is that this is not novel. It is very welcome, but it's not novel. This has been said, and it is a current trend, and I hope it continues to be said by investment tribunals. For instance, the Saluka versus Czech Republic Tribunal has said that the state conduct must be, in order for state conduct to be reasonable, it must bear a reasonable relationship to a rational policy. And this has been further specified by the AES Tribunal, where it defines that there must be a rational policy, and that this policy must be reasonably related. The action must be reasonably related to this policy. And it has said that a policy is rational when the state adopts it following a logical and good sense explanation with an aim of addressing a public interest matter, and that it is reasonable when there is an appropriate correlation. I will not go into the other claims that Krista has I will just very quickly give my concluding remarks. Which is that this case is a very welcome case because it confirms the state's right to regulate. From the expropriation perspective, the takeaway is that general bona fide regulation that is not discriminatory, that is directed to the protection of public welfare, will not be considered expropriatory and therefore will not need to pay compensation. But the impact of the measure must be proportionate to its goal, and there might be a discussion in future cases of this proportionality requirement. And from the FET perspective, it will require measures to be reasonably related to rational policies, but gives great deference to states. And one point that is important, and the tribunal says so, is that manufacturers of harmful products have no reasonable expectation of regulatory stability. And with that, I conclude. Thank you.
Many thanks, Sabina. I take from your analysis, I think you complemented a lot what was said before, especially from your perspective of investment law, regarding the right of states in the light of bilateral agreements. And then your analysis of indirect expropriation, also in connection with the challenge measures in the case of Uruguay. But I think what I also take from what you said is that in your view, this is not novel in terms of trends from arbitration tribunals. Maybe you could complement that afterwards. But this is at least my take of what you said. Please, Ernest Ulrich, you have 10 minutes.
Good evening, everybody. I was asked to offer a few comments from the point of view of WTO law. And let me say I have been involved in WTO dispute settlement and GATT dispute settlement for 35 years, but I'm not in any way involved in this tobacco dispute. So the tobacco disputes were brought to the WTO in 2012, 2013 by 5 WTO members. And the panel was established in 2014, and there are about 60 third WTO members involved in this dispute. So the panel announced that it would require quite a lot of time for dealing with these third-party interventions also, but the panel hopes to submit the panel report before the end of this year, and the dispute is confidential, and so I cannot reveal any inside knowledge. And if you look at the legal claims in the investment disputes, you see that the legal claims in the investment disputes are very different from the legal claims in the WTO dispute settlement proceedings, which focus on violations of the GATT, of the TBT agreement, and of the TRIPS agreement. But nonetheless, if you listen to the conclusions of Sabrina or to the conclusions of Christa, which emphasize the judicial recognition of the sovereign right to regulate, the relevance of the Framework Convention on Tobacco Control, judicial deference, all these issues will also come up in the WTO disputes. So what I shall do in the 9 minutes, which remain, I shall start with a few points on legal methodology, because we have this very strange situation that there are dozens of disputes over tobacco regulation at the national level, at the regional level, at in UNCITRAL or ICSID arbitration in the WTO, and here the tobacco countries deliberately exploit forum shopping and rules shopping in order to either prevent or delay health regulations limiting the sale of toxic tobacco products. So here the national, the regional, and the worldwide courts are confronted with legal methodology questions, which have been discussed. I mean, for any lawyer among you, you probably have read the books by Professor Hart and Professor Dworkin on legal methodology. How to define the applicable law, how to define the interpretation methods, and so far. But both Professor Hart and Professor Dworkin have completely ignored international law. And so it is useful to reflect on these legal methodology problems from an international legal perspective. And you will see that international law is much more developed than what Hart and Dworkin discussed over more than 35 years. And secondly, I will offer a few comments on the pending WTO dispute. And these problems have been discussed in great detail in a book which I published 4 years ago, International Economic Law in the 21st Century. So why do we have this forum shopping and rules shopping? It is inevitable because international economic law is legally fragmented in a world composed of 200 sovereign states, and we have mainly 5 competing conceptions of international economic law. Most diplomats emphasize international economic law as part of international law among states, and the paradigm for the settlement of disputes is the International Court of Justice, but the International Court of Justice has decided very few disputes on trade or investment or intellectual property rights. Then private commercial lawyers say international economic law, the transactions are based on private commercial law, and there are so the paradigm of dispute settlement is arbitration, and there are very different theories and modalities of arbitration. I don't have the time to go into that. Then we have the WTO as a multi-level economic and legal regulation of the world trading system. But the WTO is not limited to states, so we have state actors like Hong Kong, we have supranational actors like the EU. The WTO also protects individual access to domestic courts or judicial remedies in regional free trade areas, but this judicial remedy system is disconnected. So the domestic courts usually do not take into account WTO law or WTO dispute settlement rulings, rather rarely. The fourth paradigm is global administrative law. So we have administrative tribunals in the UN, in the ILO, in the International Tribunal on the Law of the Sea, and the focus here is on administrative law principles. And then we have European courts like the European Court of Justice, the EFTA Court, the European Court of Human Rights, which emphasize the constitutional dimensions of economic disputes. They derive derive their legitimacy from protecting fundamental rights. So this is, again, a very different approach. So the fact is that the applicable law, the applicable dispute settlement procedures, the judicial methodologies in all these jurisdictions differ, but they are confronted with common problems. So how to define the applicable law, how to define the interpretation methods, how to respond to legal uncertainty. And here, I think international law confirms very much the positions defended by Professor Dworkin against what has been advocated by Professor Hart. That is, all courts proceed today from what we can call inclusive legal positivism. That is, international economic law does not only consist, as claimed by Professor Hart, of rules of primary conduct and secondary rules of change, adjudication, and recognition, but international law, also WTO law, emphasizes very much the existence of general principles of law. And the methods of treaty interpretation as codified in the Vienna Convention explicitly recall the need to interpret treaties to settle disputes in conformity with principles of justice, whatever that means. So here, these are positions defended by Professor Dworkin, and the legal integration requirement, which was emphasized by Professor Dworkin, is explicitly recognized in Article 31 of the Vienna Convention on the Law of Treaties. And also, the WTO is committed to sustainable development. And we now have, the sustainable development principles as defined by the UN General Assembly, again, focusing on the need to overcome this fragmentation and to interpret international law in a coherent manner. And the main problem, I think, which judges face here is that many of these rules are indeterminate, that many of the treaty rules are incomplete, and then Professor Hart did not offer any methodology for responding to theoretical disagreements, to clarify how indeterminate rules should be judicially applied. And here, Professor Dworkin emphasized the need for linguistic, jurisprudential, doctrinal, and judicial justifications. And that is the real difficulty, I think, in all these tobacco disputes. And the question also, should these different jurisdictions cooperate, judicial exercise, judicial comity? What is the relationship in international law between political power and judicial power? How do you justify judicial power vis-a-vis the claims of diplomats? We are the masters of the treaties and we insist on member-driven governance in the WTO. This is medieval because all WTO members have recognized human rights and democracy, and state sovereignty today is limited by human rights and democratic principles, constitutional principles. So the plain packaging dispute in the WTO differs from the previous tobacco disputes by the fact, I think, that the Australian measures are non-discriminatory. They are based and justifiable by the Framework Convention on Tobacco Control, ratified by more than 180 states. But here, a tricky legal problem arises from the fact that one or two of the complainants have not ratified the Framework Convention on Tobacco Control. So, as a judge, can you refer to Article 31, paragraph 3c, and apply the Framework Convention on Tobacco Control as a relevant context, even if one or two of the complainants have not ratified the convention? In my view, the answer is yes, because the relevance, the legal relevance, and the evidence submitted in the context of the Framework Convention on Tobacco Control is not dependent on the fact whether the Dominican Republic has ratified the Framework Convention. Then what is new in the current dispute is the focus on the TRIPS agreement, and here the Doha Declaration on Health Protection will be very useful. Judicial comity probably will not play a role because here the focus of the complaints is on violations of GATT, of the TBT agreement, and of the TRIPS provisions, and here the WTO is the central worldwide jurisdiction which has to decide these issues, and whether they will mention that investment tribunals or national courts or European courts also have decided that trademarks only protect negative rights, not positive rights. That is a marginal issue for the WTO, I think. If you look at the complaints that GATT rules have been violated, I think the evidence suggests that there are no violations of Article 3 or of Article 9, paragraph 4. And even if there are any GATT violations, then I think here the WTO jurisprudence clearly suggests that the health protection measures, plain packaging regulations, can be considered as necessary and justifiable in order to limit the sale of toxic products. There's empirical evidence that plain packaging reduces the consumption of toxic tobacco products. The Framework Convention on Tobacco Control has set up a very complex protection system which justifies judicial deference, I think, and WTO jurisprudence has recognized that health protection is one of the highest values recognized also under the WTO agreement. With regard to the agreement on technical barriers to trade, you know that the appellate body has ruled very courageously that even though the TBT agreement does not include an exception similar to GATT Article 20 on protection of health, that the balance between trade rules and health protection under the TBT agreement must be similar as the one under GATT, and the appellate body justified this by the preamble of the TBT agreement. So I think here again I would tend to believe that the panel will not find a violation of Article 2 TBT agreement and will say that 2 minutes, wonderful. So we'll find that even if there is a violation, then here the Framework Convention on Tobacco Control could be construed as a technical regulation as defined in the TBT agreement, which is non-discriminatory. And the tobacco measures adopted by Australia seem to be non-discriminatory and proportionate in the light of what the Framework Convention on Tobacco Control recommends. With regard to the TRIPS agreement, I think this panel report will be very important to clarify that what has been said with regard to the TBT agreement is also true for the TRIPS agreement. The TRIPS agreement does not include a provision similar to GATT Article 20, so there is no explicit exception for protection of public health, but Article 7 and Article 8 explicitly recognize the need for balancing and for protecting public health. So here I expect that the WTO judges should use Article 7 and 8 of the TRIPS agreement as an explicit confirmation of their judicial power to engage in balancing between the intellectual property rights and the health rights involved. And I think that probably they will find that all these claims of violations of Article 2, 3, 15, 16, 22, 24, 20 of the TRIPS agreement are not persuasive, that here the limitations are non-discriminatory and justifiable under the TRIPS agreement. Finally, should they engage in judicial comity? I mentioned that, there are lots of other national or European or investment arbitrations and judgments which have confirmed that trademarks are negative rights, that the plain packaging measures tend to be non-discriminatory if they respect the Framework Convention on Tobacco Control. But I assume that the WTO panel will probably not too much refer to this other jurisprudence, because the focus of the legal claims is very different. So the basic conclusion, and you find a detailed analysis in a book which is coming out now, which I have published on multi-level constitutionalism for multi-level governance of public goods. I think the basic conclusion is, even in these very diverse jurisdictions at national, regional, or worldwide levels, judges should take the customary rules of treaty interpretation more seriously than they often do, and they should respect the explicit requirement of interpreting treaties, settling disputes in conformity with principles of justice. And here I think they should aim at coherent interpretations which avoid this kind of forum shopping and rules shopping and the risk of incoherent judgments. And in my view, the WTO balancing principles read conformity with the Framework Convention on Tobacco Control justify the WTO consistency of non-discriminatory plain packaging and regulations, even though some people say that with regard to cigars and geographical indications, there might be a problem with regard to Australia's restrictions on the packaging of cigars. But I think this, again, this is not a convincing argument. Thank you very much.
Thanks, Ernest Ulrich. I think was, again, an excellent complement to what we have heard before. I think you underlined this fragmentation of international economic law and the need to look at the general principles of law. And I think it was quite interesting, at least for me, when explaining WTO system, the analysis that you made about basically two agreements, the TBT and the TRIPS agreement, that no doubt will have an impact in what might happen in WTO in this particular case. To finalize this round, Ben, you have 10 minutes.
Thanks very much, Pedro, and thanks very much to the Centre for inviting WHO and me to participate in this panel, and for the Graduate Institute for hosting it. As I think Krista mentioned, WHO submitted an amicus brief in this dispute. It's in the public domain, so I'm not going to outline exactly what was in the amicus brief, but we can certainly discuss it in question time, if you like. What I would like to do is just make some observations about important principles of law that come out of this award that are more broadly relevant to international courts and tribunals, specifically around questions relating to the efficacy of different regulatory interventions and the standards of proof that are applied to them, first. Second of all, some observations about the treatment of trademark rights as property rights in this dispute. And then third of all, some observations about the way in which the Tribunal received the amicus briefs that were submitted in this dispute. Before I do that, I think there's some very important context around tobacco control and the way in which tobacco companies litigate that needs to be said in order to understand the proper context of the arguments that Philip Morris made in this dispute. So tobacco companies and tobacco industry front groups routinely bring claims challenging tobacco packaging and labelling laws and regulations. And they routinely bring these claims in contexts where they are well aware that consumer understanding of the risks associated with tobacco consumption is poor, particularly in countries with low levels of literacy and low levels of health risk knowledge. It's also, I think, important to recognise, as Krista did, that the harmfulness of tobacco use was not in debate in this dispute and is not in debate in really the public domain with respect to tobacco products. And that's important because it removes one of the grounds on which regulatory measures are often challenged. There's no question here about the risk and its magnitude. 50% or more of regular smokers will die as a consequence of smoking. Yeah? So this forces the tobacco industry into making a handful of different arguments, irrespective of their merits, I should add. The first argument that the industry is forced to make is that the interventions themselves that governments use to address these risks to life and health are ineffective. The second argument, a legal argument in association with this, is that governments should be held to strict standards of proof as regards the effectiveness of interventions to address these well-established risks. And then thirdly, particularly in the context of packaging and labelling measures, tobacco companies seek to stretch the nature of their property rights, and specifically trademark rights, by arguing that they constitute rights that in fact they do not, whether it be under domestic law or international law. And all of these questions raise big public policy issues concerning the capacity of courts, both domestic but particularly international, as fact finders on complex questions of science and evidence. And in the context of international courts specifically, they raise questions about the proper role of international courts, whether they should function as a court of final appeal about the merits of domestic regulatory policies designed to address well-established risks, or whether they should focus more narrowly on implementation of their mandates. So in this broader context, I want to make some comments first about the efficacy or effectiveness of different interventions and standards of proof. As Chris has explained, here and in investment treaty disputes more generally, there's widespread consensus that tribunal members, that arbitrators should not and do not stand in the shoes of a domestic regulator or legislator when it comes to making decisions about how risks should be addressed. But there is some disagreement on what the appropriate standards of proof are with respect to different interventions. And it's important to recognise, as we think through the broader implications of this award, that international courts face a number of challenges when it comes to complex questions involving scientific issues. Judicial and scientific methods are different. There are important limits on document discovery in international disputes and on the examination of witnesses that often are not seen at the domestic level, which facilitates, I think, a more robust fact-finding exercise in many instances. International courts are distant from domestic context and somewhat removed from it. And all of this raises questions about the allocation of authority to international courts and whether it's appropriate, again, for courts to serve in effect as a court of final appeal on questions of complex regulatory policy. In addition to which, on issues such as tobacco control, including in this dispute, there are methodological difficulties or challenges in the scientific context alone. Drawing causal inferences about the impact of a policy can be difficult. In the context of regulatory schemes where governments implement a range of different interventions in concert with one another in order to achieve an overarching regulatory goal, it can be extremely difficult to control for different variables and determine the impacts of any one intervention. Impacts are not always immediate. In many instances, such as in the context of tobacco packaging and labelling measures, the measures are designed to achieve impacts over the long term. In some instances, generational change, in thinking, generational change in awareness of the risks associated with tobacco use. And there are broader challenges here when we think about also the role of expert witnesses and expert evidence in international disputes. And it raises, I think, an important question about the value of different parties bringing expert witnesses to different disputes, including on quantitative issues, versus the use of traditional legal methods by courts, judicial approaches to determine the reasonableness and the appropriateness of interventions to address a well-established risk. So, having outlined some of those, I think, broad policy concerns that are relevant to the health context in international law, I just want to touch briefly upon the standards of proof applied here with respect to expropriation and fair and equitable treatment. So here on the issue of expropriation, I think very importantly and appropriately the Tribunal acknowledged the difficulty in isolating the impact of different tobacco control measures implemented as part of a regulatory scheme. And here I'll quote the tribunal. The tribunal states, "But the fact remains that the incidence of smoking in Uruguay has declined, notably among young smokers, and that these were public health measures which were directed to this end and were capable of contributing to its achievement. In the tribunal's view, this is sufficient for defeating a claim under Article 5.1 of the BIT." In essence, the tribunal takes a judicial method in resolution of the issue under Article 5.1 and expropriation. And it takes a similar method in the context of fair and equitable treatment, looking at whether there's a manifest lack of reasons, bad faith, irrationality. And as has already been stated, the tribunal states that it's not necessary to consider the actual effects of the measure, or for that matter, the discordant or disagreeing expert evidence, specifically in the field of marketing, brought by each of the parties to the dispute. The tribunal considers that what is important is whether the measure was reasonable at its time of adoption. This is specifically in the context of analysis of the fair and equitable treatment standard. Again, the tribunal adopts a judicial method rather than stepping too far into questions of scientific dispute. In doing so, I think very importantly from a public health perspective, and certainly from the perspective of the World Health Organization, the tribunal relied upon the WHO Framework Convention on Tobacco Control. It relied upon the convention itself, as well as guidelines to the convention that were developed and adopted by consensus of the parties to the convention. And I'm drawn specifically to the fact that the tribunal used the convention as a point of reference for determining the reasonableness of the measures. And then specifically, I think it's important to dwell upon the fact that the tribunal notes there's no requirement for Uruguay to independently perform additional studies on the effectiveness of making warnings cover 80% of the front and back of the tobacco pack. And this is important because in the guidelines for implementation of Article 11 of the Framework Convention, which address packaging and labelling, it's recognised that the larger warnings are, the more effective they are at achieving their policy goals. And these guidelines, as they expressly state, are based upon the best available evidence and the experience of parties to the convention. In effect, they rely upon a body of evidence testing the effects of large graphic health warnings on tobacco products from different places, at different times, and using slightly different approaches, where those studies produce consistent conclusions. And in this sense, they produce generalisable knowledge that merits being included in a guideline to the Framework Convention on Tobacco Control. The tribunal's recognition that Uruguay need not conduct its own independent studies, consumer testing in this context, I think is quite important. It places proper reliance upon an international instrument developed by states that today has 180 states parties. So in summary on efficacy and standards of proof, I just want to say that the tribunal's approach speaks to the merits of looking at the totality of the evidence and looking at it in a judicial way, rather than being overly focused on competing views of expert witnesses, particularly in a context where the views advanced by the Uruguayan government represent the mainstream scientific opinion on this, as well as views captured in international instruments adopted by consensus at the multilateral level. I have only 1 minute, so I'll just very quickly make some comments about trademark rights and then amicus briefs in this dispute. As it's been recognised, the tribunal stated that the Uruguayan Uruguayan law did not provide a positive right to use trademarks but more generally that none of the conventions to which Uruguay is a party provide such a positive right. But importantly, it recognises that the exclusive rights that a trademark owner or rights holder has or derives from a trademark are exclusive vis-à-vis third parties, that is, others who may seek to use their mark or a similar mark in the course of trade, but not an exclusive right vis-à-vis the state, and more specifically, not an absolute right that can in some way prevent the state from regulating in the public interest. So trademark rights under international law, in the Tribunal's view, are subject to the regulatory authority of the state and a broad authority. Finally, I would just say that with respect to amicus briefs and the Tribunal's reliance upon an amicus brief by the World Health Organization jointly with the World Health Organization Framework Convention on Tobacco Control Secretariat, and then a separate brief by the Pan American Health Organization is obviously very welcome from our perspective, and as we understand it, is really the first time that a tribunal and investment treaty arbitration has placed such reliance upon an amicus brief. Nonetheless, obviously, we think that it took the right approach. So with that, I'll say just finally, I think as the other panellists have recognised, I don't think there are any great surprises here on the law or on the facts. And it tends to confirm the regulatory authority of the state. But the fact that a dispute like this lasted almost 6 years, the Uruguayan government had to front almost $10 million to cover the cost of the arbitration and its legal fees, raised very significant questions about regulatory chill and the way in which the investment treaty was used in this instance. Thanks very much.
Thank you, Ben, for complementing this presentation, especially your emphasis on the implications of the right to regulate. And I've seen the approach that was taken by the tribunal, that you call it the judicial approach or the judicial method. And basically, from your perspective, from the side of WTO Framework Convention on Tobacco, I think has been excellent presentation from the panelists. What I will do now is I will allow the panelists to take not more than 2 minutes to complement and maybe comment on what has been said by the other panelists, and then I will give the floor to the participants. Maybe we start with you, Krista, but now it's 2 minutes.
Okay. Very briefly, I think all of us had sort of similar approaches to this. I think my only comment is I think I am surprised. I am surprised by this decision. I think it goes further than one might have thought it would go, particularly in giving governments the green light to try things new. And maybe this surprise comes from my background also in trade, because I think that this is something that's really important. I don't think that if this had been the appellate body, it would have given such credence to just go try it out. See what you can do. Yeah, you're beyond the international standard, but that's fine because you've got a problem and you've got to solve it. I think my feeling is the WTO is much more restrained about going beyond sort of the lowest common denominator that has come out. That said, I think there's also a bit of, I'm just curious as to what everybody else thinks, maybe people in the room or my colleagues, how much of this decision is based on the fact that it was a tobacco company, that it is about an industry that has gone on and as Uli pointed out, really been challenging people all over the place with the knowledge that, hey, everybody's going to be watching this decision. And if we come out and say, you can't do this, even on any of the grounds, the symbolic work, the symbolism there would just be really probably hard to control further on. I think there were good arguments on the side of Philip Morris. You could have interpreted it otherwise. But I think sort of reading the sign of the time, reading the writing on the wall, I think the tribunal made a very clear and logical argument, but it's not the only argument that could have been made.
Fantastic. Sabina.
Well, first I want to address Pedro's comment to me as to whether it was novel or not novel. As I think also Ben recognizes, I don't think the award is novel in the sense that what it said, or the rationale behind it, the different findings, has already been said. So that it's not new. What could perhaps be seen as new is that it hasn't been said very often, at least in terms of expropriation. At least lately, this whole police powers approach had been left aside by many tribunals, and it takes, the award goes a little bit further by saying, well, we take a stand. But I also want to highlight that the tribunal did not use this as its primary argument. In the logic, or at least my logic, of how you analyze an expropriation, if this measure is not expropriatory by nature, then why do we even have to go into it causes substantial deprivation? However, they do this the other way around, and they say there's no substantial deprivation, and by the way, it also is a police powers measure. I wonder what would have happened if there had been a substantial deprivation. Then I'm not so sure tribunals like to go so far as to allow complete or absolute takings go uncompensated, but that is a question that does not arise here. So it is more novel on expropriation than it is in terms of fair and equitable treatment, because there the deference given to states in taking policy measures is higher. And I also wanted to come back to your argument, the different novel part, which is whether the measure was new and different. And I think, if you ask me, I think the reason, I have no reason to believe this except my intuition, the reason the tribunal makes an emphasis on this is because there was a dissent on this point. And I can go back to it if somebody asks me the question, so I don't pass my two minutes. But that will be, I will throw it out there.
Yeah. Thank you.
I think the enormous danger of this legal fragmentation, which we see in international law generally, is that you do not only prioritize unilaterally special interest groups, trade interests in the WTO, investment interests in bilateral investment treaties, but the diplomats do not assume their responsibilities vis-à-vis civil societies. I have worked for almost 40 years in international diplomacy, and I think the reality is just diplomats pursue their self-interests. And they pursue their self-interest in limiting their accountability vis-à-vis civil society, vis-à-vis we, the citizens, as the constituent powers and the democratic principles, to limit their democratic accountability, to limit their judicial accountability. So WTO rules are ignored in domestic courts because, diplomats think that is how things should be. They should not be held accountable in domestic courts. So the importance here is that these fragmented legal regimes one-sidedly prioritize trade interests or investment interests, but they do not regulate in a coherent manner how to protect public health. It's a scandal that for 100 years, the most toxic products can be sold lawfully in any shop, and in the last century, 100 million people have been killed by tobacco products. So I think the conclusion is the World Health Organization And the other specialized agencies defending, public health or food security, they have an enormous responsibility here. And I think it is a very welcome fact that in both these investment disputes and in the WTO disputes, you have these amicus curiae submissions, you have the active involvement from the World Health Organization, from other health organizations, and they are extremely necessary for protecting citizens against abuses of international economic law, abuses by power-oriented diplomacy.
Oh, there's a lot to cover in 2 minutes, but let me just focus specifically on this idea of Uruguay having done something novel or acted as a first mover. I think it's important to clarify, and I hope you're talking of the single presentation requirement rather than the large graphic health warnings. There are now a number of countries that have larger warnings than Uruguay. With respect to the single presentation requirement, I'll give you a 30-second history because it's important. The genesis of that begins in US courts with an action against major tobacco companies, including Philip Morris, under the Racketeering and Corrupt Practices Act, because the companies were using descriptors like light, mild, and ultralight to convince consumers that those brand variants were less harmful than the full flavoured product. When found to have violated the Racketeering and Corrupt Practices Act, Philip Morris in particular changed its business structure so that it could continue to use those descriptors on products outside of the United States in countries such as Uruguay without attracting additional liability under the same act. Now, when those misleading descriptors were then changed or banned in Uruguay and other countries, the company rebranded its product to silver, gold, etc., and explicitly instructed retailers that when customers came in asking for light, ultralight, etc., then they should be given the equivalent colour, whether it be silver, gold, etc. So what Uruguay is doing here is not in fact that novel or radical. It's a recognition of the state's general power to prohibit misleading conduct. And specifically here in a context where the misleading conduct has a health consequence. And yes, it is a new way, it's a way that other governments haven't necessarily used to address that issue. But it's fairly well founded in principle, rationality, reasonableness and common sense.
Thank you for keeping the 2 minutes limit. As I mentioned at the beginning, we have the opportunity now to maybe invite you to raise questions, make comments, tries to be brief, address the question to one of the particular panelists or the panel in general. And please, as we are webcasting, try to speak clearly using the microphone and limit your time according to what we have as a time limit of the meeting. I see, please, why don't you identify yourself?
Yes, my name is Vandana Gyanchandani. I'm from India. I'm a student at the Graduate Institute. I have a question.
Could you speak closer to the
Yes,
microphone?
so I have a question regarding the plain packaging regulation as such. Within the ambit of WTO and as well as investment, I believe that having a very absolute rule on plain packaging against tobacco companies which have a huge lobby to enforce their will on politicians, as Professor Petersman said, that diplomats are bound by political implications of their decisions, and regulations are nothing but coming out of legislative practice through politicians. So I believe that having plain packaging as an absolute regulation to regulate trademarks of big tobacco companies at one instant is from the regulatory point of view as well as from the law point of view not going to help the cause instantly, it might help the cause in one country who might win the dispute, but in the long term, if you give preferences to cigarettes which have less tobacco, by giving them the preference of or leeway to have a little more of the trademark in the in the packaging, and cigarettes which are actually more harmful to citizens in terms of the tobacco content. And why only tobacco? It's alcohol. There's many other toxic substances that public is exposed to. So I think we should go step by step, and having an absolute regulation and having a conflict with big tobacco companies having big lobbies is not going to help the cause practically, even though legally it might make it practical for some countries, but not all countries.
Okay, thank you. I will take probably 2 or 3 questions, and then I'll give the floor to the panelists.
Yes, thank you. My name is Marina Fultea from Trade Pacts.
From what?
Trade Pacts. I have 3 questions. First one, since more than 2 people have referred to the fact that the tobacco industry is using international and domestic courts, etc., does any of you have data actually on the statistics on how much tobacco has used the investment dispute settlement regime in your Krista part? And here on the WTO side, since Professor Petersman also said that there is a big use of the systems by of this specific sector, how many cases there have been, in particular regulatory cases, because we speak about regulation from what I understand when you refer to plain pack, etc. So how many cases have there been in the WTO addressing regulation in tobacco? My data says that it's very low. So can we really say that there has been a use and abuse of the system? So up to you. The second question, Professor Petersman, you are saying 2 claimants in the WTO plain pack are not members to the FCTC. And if I understood you correctly, you're saying that this is not a problem. My understanding is that somehow it creates a problem because it sets different standards, sets of obligation with respect to different members at WTO. And to my knowledge, this is a bit problematic actually. And I think Just is in the room. I think he looked into that. He can add on this question. And the third one, I'm also a little bit surprised that this panel takes the fact that the trademark is, you take it for given that the plain pack does not infringe a trademark right, and the panel actually has not yet deliberated on that. And it's not excluded that in some contexts, somebody said that there is negative, positive, etc. But I can also tell you that I've seen writings whereby it is not such a clear-cut question that the TRIPS agreement, for example, can we read they are positive or a negative, right? So I think we cannot really be so sure, or at least now we cannot speak so clearly about the outcome. So I'm myself curious to see the panel decision, what they will say on that. I would be surprised if they just defer to your point, what you had on IP, although I fully agree that in other points that the decision of the panel may be very close to what you said. Thank you.
Thank you for the clear question or observation. Please take.
Hannes Schlimmern of WTI Advisors. Thank you very much, everyone. That was fantastic. I do have 2 questions. I think the first one is on the day or the week or the month of CETA. I think a question is, are we looking at the dusk of ISDS or are BITs, the bilateral investment treaties, finally growing up to place themselves in a continuum of constitutional principles, as Ernst Ulrich is hoping, and I'm very much on your side on that one. Or are we looking at a race between the two, like tribunals finally coming around to, accepting public policy as what it probably should have always been? Are they perhaps coming too late now that ISDS is in such trouble, publicity-wise? I stopped smoking 8 years ago. I'm all for tobacco regulation, and yes, tobacco is really bad. Let me just say that. But what I'm saying now sounds as if I'm going the other direction, but I am very tempted. I've seen so many panels, and everyone just agrees, bash them. And I think we have a big problem here, and we have a constitutional problem. We have a problem that the main party here is missing. It's the consumer. So when we talk about human rights, let's please include the consumers. And in this case, that means smokers. Yes, they're hurting themselves, and sometimes they are annoying others. But as long as they are outside, no one is around, and the smoke evaporates, yes, they're hurting the climate, but other people do a lot worse things than that. So let them, when they just hurt themselves, what is it that we really want from them? But my problem is not that. My problem is, do we have a constitutional, a setup problem, an international economic law problem, perhaps a WHO-related problem, perhaps a philosophical problem with the fact that we're actually in a situation where the companies are making the case for their consumers. I'm choosing my words carefully. Yes, of course they're trying to make a profit, but it's true that the smokers also want to smoke, right? I think we can agree on that. So if we cannot completely forget that they exist. In fact, they are probably the biggest lobby group, but as all consumers, and that brings us back to a fundamental problem that we have in both BITs, and Ernst already said it in not so many words, and in the WTO, the consumers don't really have much of a voice. The consumers are supposedly taken care of by their democratically elected governments. That's why the governments should speak. But I think the enthusiasm, like prohibit tobacco, is a bit like kill all terrorists. I'm just provoking here. But in principle, you can always go further than that, right? I think we need to be sensitive to the fact that some people want to consume this stuff, and in the absence of babies and people who get annoyed. But what is it that we want from them? Again, I'm not asking that question. I'm asking the question, do we have a problem more philosophically? And Krista said, let's think about other products. Is it problematic that the consumers are dispersed and don't really speak in these disputes? And how can we make their voice be heard? Or is their voice heard enough by us allowing states, or states together, as in the WHO, to regulate? I'll stop there. I had more. Thanks.
I might take another question before we go to the panel, please, over there.
Can you hear me? Good afternoon, everyone. Thank you for your highly insightful comments. My name is Panos Theodoropoulos. I'm from the Master in International Dispute Settlement here in Geneva. And I'm just taking a very convenient cue from the previous question, since I'm a smoker myself. And I felt that partly I had to do the devil's advocate in this conversation. I have two questions directed first to Mrs. Nadakavukaren, really sorry, and Ms. Sacco. This would be concerning the Sonderopfer theory, the theory of the greater sacrifice, leading to whether, even in the concept of legitimate policy decisions made, there is still a need for compensating damages caused. This touches to the question that Ms. Nadakavukaren addressed herself before, and so I would like the input of everyone on this. The second question is directed to Mr. Petersman, and it has to do with my understanding of the carve-outs in modern BITs, as referred in the presentation of Ms. Sacco, being slightly modeled after the carve-outs found in, say, the GATT or the GATS, Articles 20 and 14 respectively. Would you think that there is ground for suggesting that it could also work the other way around, raising within the ISDS system claims based even vaguely on WTO principles? That's it. Thank you very much.
Okay, thanks. I don't know if there are some questions that we have from... No? Okay, I will invite... Would like to react first. to some of the questions. You are not obliged to respond to all of them.
Sure. Thanks very much for the opportunity. Perhaps I'll also address them in reverse order. I want to touch, first of all, on this question of compensation and whether or not there is, in fact, a case to compensate here. And specifically, I want to mention a moral hazard, which is that when an industry or an individual does something that's knowingly harmful to the public interest, he, she, it should not be compensated by the government to cease doing it. Because in effect, all we are doing is sending a message that the government is ultimately an insurer that will compensate individuals, industries, corporations in the event that they do something that's harmful, whether that be in a health context or in other contexts. And I think that's deeply problematic, particularly in the tobacco context, where the harms associated with tobacco products are so well established, and where the industry, including Philip Morris, has specifically acted so as to deceive consumers about the risks associated with specific brand variants. There've been a few mentions in the questions about other products, non-tobacco products, and the application of this discussion to non-tobacco products. I think it's very important to recognise that tobacco products are unique products. Nicotine is addictive, and tobacco products as a consequence are addictive. As I mentioned earlier, 50% or more of regular smokers will die as a consequence of smoking. There's no other consumer good that, when used as intended in this way, harms its consumers to this level. It's also important to recognise that when we speak about specific interventions, whether they be the interventions that the Uruguayan government implemented here, such as the 80% pack warnings or plain packaging, they're spoken about in the context of tobacco products because there's a large body of evidence establishing both the risks associated with tobacco products and testing the efficacy of different interventions with respect to tobacco products. And I say this expressly with respect to plain packaging. Plain packaging is recommended in guidelines to the WHO Framework Convention on Tobacco Control because there is a body of experimental evidence that tested the impacts of plain packaging in different places, in different times, and in slightly different forms, that has generated broadly consistent conclusions about the effects of that intervention. We at WHO do not have any instrument, whether adopted by member states or others, that recommends or encourages plain packaging on other consumer goods. So for us, the discussion on plain packaging ought to be specifically confined to tobacco products, because in that context we have a strong evidence base to suggest that it's going to reduce the appeal of tobacco products, it's going to make health warnings more effective, it reduces consumer misperceptions associated with different products, and ultimately contributes to declines in prevalence of smoking and tobacco use more broadly. And then finally, just on this question of consumer rights, I don't want to get into the philosophical questions associated with consumer rights. Only note that in this context, the addictiveness of nicotine and therefore tobacco products is an important factor to take into account in any discussion about individual liberty. But more particularly when we look to the international level and the approach adopted by WHO and the Framework Convention on Tobacco Control, it is a public health approach. It's an approach focused primarily on reducing demand for tobacco products. This can be contrasted with the criminal law approach administered by the UN Office on Drugs and Crime with respect to other narcotics, which is aimed at reducing the supply of products, including to consumers. So the Framework Convention on Tobacco Control recognises that consumers have a right to know about the harmfulness and the effects of consuming tobacco products. And in this instance, the Uruguayan government was seeking to reduce consumer misperceptions about the harmfulness of different brand variants. So in fact, the interventions that we're talking about here are really very consumer friendly and go back to this core principle that consumers have a right to know what they're consuming.
So I also want to take this compensation question because I think it's fascinating. The key question, the million-dollar question, is who pays for the costs of regulatory change? Is it the state, or is it the private person who has to suffer the effect of the measure? I mean, you could say it's the person, or you could say it's the state who, through taxpayers, basically distributes the cost to the entire population of the country. I have to concur with Ben on the issue of moral hazard, and this is, I think, what comes out of these decisions that we've commented today. Not only Philip Morris, but Kim Tura and others like that, Methanex. If you are the one putting out something that is dangerous, then you should suffer the brunt of the regulation. However, if you are not, then the question is more difficult. And I would submit that perhaps the way to look at it is through the principle of proportionality. And this has already been said, for instance, in Zurich's, relying on European Court of Human Rights jurisprudence. And what, I had it in front of me. What the Zurich's concluded was that for a regulation taken in the public interest to be compensable, for it not to be compensable, it would have to bear a reasonable relationship of proportionality between the means employed and the aims sought to be realized. This was the European Court of Human Rights, and Zurich is quoting it. And in view of this tribunal, this proportionality would not be found if the person concerned bears an individual and excessive burden. So I think that if a real damage has been caused by a regulation and it directs, or maybe not directs because we're talking about something that is non-discriminatory, but if it falls more on some people than others, perhaps this is one way to look at it.
Just a brief answer to your question. Do WTO principles possibly assume more importance in investment adjudication? Let me just mention there have been several NAFTA investment arbitration procedures where the argument was made that in the examination of whether the foreign investor was discriminated, you could use WTO dispute settlement rulings establishing such discriminatory treatment and interpret the umbrella clauses of the investment treaties as transforming the WTO dispute settlement rulings into an integral part of the investment law. Second question, informed consumer, I think that has already been clarified. But what is the lesson of CETA? Hannes, you mentioned CETA and investment dispute settlement. And I have written a policy brief for the College of Europe in Bruges, and they have published it on the website, where I would argue there are very strong reasons under European law that in relations between democracies, investor-state arbitration is undercutting the fundamental rights of citizens, is undercutting the much higher judicial remedies which we have in Europe or in most democracies. So I think we should distinguish between investment disputes among democracies where domestic judicial remedies should be more than adequate. National treatment is all which is required, I think, even though Canada's constitution does not protect private property, so there is a potential problem. But here the history of bilateral investment treaties has been to establish these investor-state arbitration as a substitute for the lack of reliable adjudication in many less developed capital importing countries. Then your question The number of cases, I think, is not important here. I mean, I mentioned that in the WTO there are 65 WTO members involved in this case, and once this case has been settled, we will see a flood of plain packaging regulations in many, many WTO members. So if this dispute, the dispute will certainly go to the appellate body afterwards, but once this has been clarified, then I think, we should not be worried about future plain packaging disputes in the WTO. There is this doctrine of precedent in the WTO. Finally, your question about Article 31, paragraph 3c of the Vienna Convention on the Law of Treaties. Normally, you are right. If a third agreement reduces the rights under the WTO, then of course, I mean, it is important that the third agreement can be applied in the WTO context only among those countries which have accepted the agreement. But here, I mean, I think the question is more how to construe the very vague WTO rules about protection of public health, how to use empirical evidence which has been gathered by the World Health Organization in the context of the Framework Convention on Tobacco Control. Is this empirical evidence relevant also for the Dominican Republic, which has not ratified the Framework Convention on Tobacco Control? And there you can make a strong argument. Yes, this empirical evidence that plain packaging has empirically contributed to reducing tobacco consumption, that is relevant also for WTO members if they have not ratified the Framework Convention. But 188 countries, I think, have ratified the Framework. 190? 180, yeah. So I think that is a very large number of countries. Stop here.
Thank you.
Yep. I won't answer some of the questions because I think they've been adequately answered already. I think one thing I want to just clarify from a discussion also to Ben, I mean, when I said that novelty is something that I think they brought out very strongly, I didn't mean that's a bad thing. I mean that's a good thing. So the lack and not requiring proof of effectivity, I also think is a good thing. Anyway, okay. I don't quite understand what you mean by not helping the cause. I don't know what cause you're talking about. The cause of health? It doesn't help to have plain package? I mean, I think the evidence suggests otherwise, but.
No, could you use the micro, please?
Just ask me a question. Just give me a question. I'll answer.
It's not a legal question. It's more about the politics of plain packaging. It's about maybe through WTO ruling we can have some countries who have human rights oriented politicians to take up plain packaging, but not all countries. And some politicians are well supported by the lobbyists, like tobacco companies, big tobacco companies. Like in US, you still have some gun laws which
okay,
needs
so
to be
but what's
changed.
the question?
So the question is, if you have strict regulations, you're just taking away the much of the trademark rights of tobacco companies. They are not going to disappear. They will be present in some countries. So to the cause that we want to inform all the consumers all over the world, we need to have progressive regulation which goes step by step, informing consumers, then attacking the tobacco companies.
Well, I mean, I think that the argument is you start in your own country and inform your consumers in your own country. We don't have prescriptive jurisdiction to require that everywhere. I mean, maybe you're right, but I don't quite see the connection between saying that in some countries you're not going to get plain packaging and therefore it harms tobacco control worldwide. I don't know this link. But let me just also say, this case was not about plain packaging, right? This case was about the single presentation requirement, which was different, and 80% is not the same as plain packaging. But anyway, Marina, statistics on tobacco arbitration, from what I know, it's 2, but there have been a lot threatened. And I think that this underlying threat is the bigger the bigger problem in terms of how this is working, because if you can use it. Oh, well, 2 out of 600. Yeah, 2 out of 600. But if you have Philip Morris going around, I mean, I don't know how many of you have watched John Oliver's segment on tobacco, but if you have Philip Morris writing to countries like Ghana and Burundi saying, if you even think about it, we're going to slap you with claims that are going to blow you out of the water financially. You don't need a claim actually filed. All you need are these kinds of letters. And I think that that's why this case is very, very important, because that puts a chill on those. I think we're watching still what happens at the WTO, and that's why I think my comment also that what the tribunal was doing here, I think was, don't get me wrong, I think what they did was very solid analysis. But there are also other ways of interpreting words that you could have also had a solid analysis that comes out in the other direction, right? And it would have been a legitimate, if bad for public health, decision. But I think here it was absolutely necessary to come out with this as a clean cut across the board. You lose on every issue. I think that was important in terms of the symbolism to quash these threats of arbitration or of investor-state dispute settlement. That said, I think your comment about the problem of the FCTC not being ratified by all claimants, and that what Willie said is that shouldn't be a problem. I would just also here say the WTO uses, for instance, the International Standards Organization standards as the international standard. They use Codex Alimentarius as the standard for SPS. Both of those organizations are completely, they are not universal participation. They're not even states participation only. So I don't think that it's a problem to say the FCTC, which has been ratified by so many states, isn't an international standard that could be used as the basis of a finding. The question about CETA, I was waiting for that. I mean, that is really the issue, right? That is really right now the issue. What does this say for CETA? What does this say for TTIP? And I mean, I'm basically thinking this is something also that was certainly in the minds of the arbitrators. And I think, if anything, this should pacify some people who are worried about it, because it shows that the system can also work. It's not a matter of the system itself being broken. And this is something that I have been considering. I should have written about it, but I haven't completely finished this, okay? But the whole idea of the the investment court system, I don't think you need it. I think that the investment system, much more so than the WTO system, is fixing itself. It is responding much more quickly to the political context and responding in ways that are becoming more open. They're becoming more amenable to public policy questions and giving this regulatory space that is being perceived as needed, maybe as a survival instinct, but hey, for whatever, I'll take it. And finally, the question about bringing WTO claims into ISDS, it has been tried. I think Eli Lilly is still out. What I think is kind of interesting is looking at this case, which I didn't get into, how the tribunal here responded to WTO law arguments made. And they were like, even if this is relevant, which basically we don't think it is. I think that was interesting that they sort of say, what the trips say, we don't have to worry about that. That's not us. We do look at what the WHO says and what the FCTC says. But I think the other problem with it is when you're talking about a WTO obligation, it's an obligation on a state and it's the right of another state. And so I think you have a little bit of a disjoint. If you have an investor claiming a WTO-derived right, because WTO is not given direct effect in most countries, right? And so can you really do that? I think that's sort of weird judicially. Maybe you could stretch it if you really want to, and if you could say, well, it's in these particular areas of TRIPS that the European Court has said, okay, they might be. But I think that you do have, I'm very reluctant to say that trade and investment cases should be seen the same way, because I think there are significant differences structurally that have impacts then. And so I wouldn't like to see that, actually. That's all I have to say about these things. I don't know if anybody else. I'm supposed to wrap up a bit of our discussion. Oh, you have a, shall I?
Let me, could we
I'll go back.
extend this a little bit? Okay, what I will do, this has been quite important, I think, the questions, the discussion. Why don't I take 2 more questions and I give the floor again to all the panelists to react, and then we will conclude. Be brief and clear, please.
Okay. We'll go out for a smoke.
Afterwards. No, we're going to go for a drink.
We're going to go for a drink, yeah. Some fat, sugar, and alcohol.
Okay, so I just wanted to contribute to, well, you posed a question to her about what was the link between the cost not being, that is contrary to the cost. I think the link is that perhaps in some countries, yes, these regulations exist, they are in place, and in others they aren't. So what could happen is, since they do exist in these other countries, and I really don't know how to put it in words. It's about contraband. Wouldn't this like smuggling? Wouldn't this, like, for example, if it restricts the use of, for example, when you say that it is limited the amount of trademarks that a proprietor can own, what if you like gold, for example, and you cannot buy gold in your country, but in another country they sell gold? Wouldn't that promote smuggling in a way? Like, wouldn't that?
There was a second question, and then we conclude with the questions.
Hi, my name is Vinay. I'm also a student here in the International Dispute Settlement Program, LLM program. My question is specifically from Ben. You say tobacco is harmful. 50% of the smokers die because of tobacco. Agreed. And tobacco is not good to smoke. It's agreed. But I want to know what is the WTO is doing, which for these subsidiaries things which are coming in the market every day, new things, for example, electronic cigarettes and all these things. What is the WTO is doing to prevent that? Like, in few years, the way you were telling, like 50% of the smokers die, tobacco smokers die because of the because of the smoking. After 5 years, if you don't stop it right now, this electronic things which are coming in the market every day, I think after 5 years you're gonna give some statistics for this as well. These are the things which are just developing right now. If WHO or anyone stops them right now, I think that'll be much better. So, what is your I want to know your comments on this.
Okay, you were referring to WHO, I guess.
No, sorry,
Yeah.
WHO.
Well, let me now turn to the panelists, and this is the concluding round. Let me start by Krista now.
Okay, probably Ben will say more about this, but the smuggling issue, I mean, the FCTC does take up also the supply side, and so that there's a protocol on tracking and tracing, so there are mechanisms in there that you're supposed to stop. I mean, there was also the issue of, do these measures actually increase illegal trade in this particular case? And they said, well, we don't really have to the evidence is out on that one. Is it a possibility? Well, yeah. But is that a reason to not go ahead and prohibit or not go ahead and pass plain packaging? I personally don't think so. But, I suppose one can differ on that in terms of political feeling. E-cigarettes, I'm not going to, I'll let Ben comment on that because it was basically a question to him. I think there is this question of, are they like products? Are they directly competitive, substitutable? All of these sorts of things. I think here, again, we get into an area where evidence is probably thin, or it's not at least at the point of saying, yes, clearly, and you have an extremely broad variety of regulation at different state levels. Some states regulate it somewhat, some states are completely open, and others prohibit it completely. So I think that it's certainly an issue that's going to come up, just as any other type of disease prevention measures will. That's all I have to say.
The only comment I wanted to make on this smuggling question is that in the end, it ended up being irrelevant for the tribunal. Why? Because what the tribunal was trying to say here is, my role is to determine whether your measure, government, is rational, whether there is a public policy that you have aimed for, whether there is a proportionality between the measure you took, is it at least capable of achieving the stated purpose? And that's where they stop, because they say it's not our role to go beyond that. And whether this measure has other problems, such as causing smuggling, is not for us to say. That is a governmental policy. You take it up with your own government, and if the government realizes that it's it's creating more problems in other fronts, well, that's for the government to decide. But it's not the role of the investment tribunal. And I think that is a very important takeaway from this case. And that's all.
Thank you, Sabine. Ben?
Thanks very much, Pedro. Just in brief, I didn't state in response to the question earlier about abusive claims a very important point, or a couple of important points. In the first instance, as a matter of legal method, we don't look to the number of claims to judge their legal character. And even if we did, we'd see two recent claims by Philip Morris against governments under investment treaties. And in the claim against the Australian government, the tribunal found an abusive process in the bringing of the claim, specifically relating to the way in which Philip Morris had restructured its business in order to bring the claim. So I don't think a quantitative method is really appropriate, but if you want to use that, then one of two, there's an explicit finding of an abusive process. Second of all, with respect to illicit trade, there's no credible evidence that packaging and labelling measures on tobacco products that are designed and well targeted to protect health in any way promote or affect illicit trade in tobacco products. Finally, with respect to electronic nicotine delivery systems, it's an extremely complex question, and there are competing views in the public health community about whether or not they should be banned, whether they should be regulated as tobacco products, or whether or not they should be subject to domestic laws governing medicines and specifically equated in that context with other nicotine reduction therapies. I would only say that for a detailed response, I'd encourage you to look at the website of the WHO Framework Convention on Tobacco Control. From 7 to 12 November, the Conference of the Parties will meet, and in the official documents of that meeting, you can find a paper prepared by WHO, which is a review of the scientific evidence associated with electronic nicotine delivery systems and the different options available to governments to address them.
Thank you very much. I think we come to a conclusion. Let me remind you of something that my colleagues have pointed out to me. There is a form, a feedback form, that is important for us. We are accountable to institutions that fund our work, and then it's very important if you could fill in the feedback form about this particular event. Let me then proceed to formally conclude the meeting, and basically on behalf of at ICTSD would like to thank all of you. I think you have been very active in participating in this event, but especially my thanks to the panelists. They have done a great work, and we really appreciate that. To the Graduate Institute that gave the facilities to this event, and especially to my colleagues in the support team, and to those that were behind organizing this event. You are all invited to participate at a reception outside this lobby. Thank you very much. It was really a very great and significant event. Thank you.